Back.
Gentleman yields back. We now go to the gentleman from South Carolina, right down the row.
Thank you, Mr. Chairman. Mr. Larkin, in your testimony, you talked about the history of nationwide injunctions and how this has not always been the practice in the courts up until the 1960s, and we've seen an escalation of nationwide injunctions by district court judges. How would you characterize the emergence of nationwide injunctions since the 1960s and its effect on the judiciary?
There are two things to keep in mind. First, the 1960s saw a rise in what is called institutional reform litigation, an attempt not just to win a case for a particular client, a particular John or Jane Doe, but to establish a rule of law that could be used in the whole category of cases to which it could possibly be applied, and then in a lot of others as well. So if you're doing it in a state, for example, you're not going to say that your client was the only one affected by unconstitutional prison conditions. You're going to sue the entire State Department of Corrections. Because what you want is to have one judge reconfigure the number of people in rooms, how the rooms are laid out, all of that. And so what you had was you had judges who, in some cases, were trying to decide with hellish conditions that would have made Dante blanch, and try to figure out how to deal with that. And so it's not surprising that in some of those cases, there are different prisons. There were in Texas, Mississippi, Louisiana, we know them all, that were absolutely awful. And a judge under those circumstances is probably going to have to do more than just say, okay, well, you have to give this one client a better room. So what you saw was a development in this regard of judges expanding the reach of the relief that was being granted. That was part of it. Part of it was also a...
Just sort of real quickly, just from a time perspective, do you think that part of this emergence of nationwide injunctions, particularly against the Trump administration now, I mean, the numbers are kind of shocking, is partly due to partisan nature of some judges on the bench?
Oh, I don't doubt that at all. I mean, if you take a look at the selection process, presidents tend to look for people who are going to rule in accordance with their views, whether you're on the right or the left, whether you're a Republican or a Democrat. I worked for Senator Orrin Hatch when he was the chair of the Judiciary Committee, and if he was the chair under Obama, you would see one type of judge being nominated. If he was the chair under George W. Bush, you'd see a different type of judge being nominated. Different ways of looking at it is common among people, and people become judges.
Speaker Gingrich, earlier you talked about, obviously, that your support of certain congressional actions that would correct or rectify the role of the courts in these nationwide injunctions, but you also talked a little bit about that the court can self-police itself. I think with Mr. Kiley, you went into at least one metric on how that could be done, but what are your thoughts generally on how the Chief Justice, who seemed to kind of brush aside criticism of the courts and just say, well, you could just go through the appellate process, how could the Chief Justice rein in his own court?
Well, I suspect that Mr. Larkin actually knows more about this than I do. But my impression is that the Supreme Court has rather strong capacity to instruct district courts in a broad range of procedures. And I think that were the Chief Justice to basically preempt Chairman Iss's bill and say, this is how we're now going to handle it. I mean, the argument in this hearing, as I understand it, is really pretty narrow. It is that with over 600 district court judges, you cannot have them each thinking they're an alternative president, and therefore there has to be an alternative system. One system would be to block all nationwide rulings. Another system would be to have it appealed automatically to the Supreme Court. So a nationwide ruling immediately got a nationwide court looking at it and recognizing that the appeals process that the Supreme Court Chief Justice referred to is nonsense when you're talking about executive branch actions, because the length of time it takes to go through the appeals process is by itself destructive of the capacity to have what Hamilton called as an active chief executive. He said that the system will only work with an active chief executive Well, you can't be an active chief executive if you have a whole bunch of Lilliputians tying you up. And this is a classic example of Gulliver and the local district judge who suddenly has blown themselves up in their own ego and decided, I too could be president, and I'll show you because I'm actually a superior president, because you have to obey me.
Right.
It's impossible to defend situation.
And in that circumstance, sir, and I know I'm over time here briefly, but in that circumstance, you have 600 presidents of the United States. Thank you, Mr. Speaker. With that,
Thank
I
you.
yield back.
Gentleman from Wisconsin.
Yeah, I don't like being here today. It's a sad state of affairs because you don't like to have to clip